So good afternoon, everyone. Welcome to this webinar on migration, civil society, and legal mobilization. So it's a webinar that is hosted by Civil Society and Migration Research Line of the Nova Refugee Clinic, and we have some members of the research team here. You can see them from the background. I am Veronica Corpeleo, the coordinator of the research group and the general coordinator of the clinic as well. So today we have two great guests that I want to thank for accepting my invitation today, our invitation of the team. We have first Markella Papadouli, who is a lecturer at London South Bank University and the Europe Litigation Coordinator of AIRE Center. That is a charity with offices located in London and specialized in legal aid, European fundamental rights, litigation, and policy. Markella is also a UK registered and Greek qualified lawyer. And within the AIRE Center, she coordinates the strategic litigation team, especially in relation to asylum and trafficking cases. And Virginia Passalacqua, just a few words to introduce our second guest as well. She's a postdoctoral researcher at Utrecht University, more specifically within the Utrecht Center for Regulation and Enforcement in Europe. She holds a PhD from the European University Institute, and in her research, she is particularly interested in litigation at the European Union level, its effects on minorities, including migrants, but also the socio-political processes that shape litigation on the European Union level. So once again, thank you for accepting our invitation today, and we will start with Markella's presentation, and then also have Virginia's presentation, and after that we will open the floor to questions. All right, Markella, the floor is yours. Thank you.
Thank you very much. Hi everyone. It's an honor to be here and to meet all of you. And thank you very much, Veronica, for the kind invitation and the wonderful introduction of myself. So indeed, I lecture at London South Bank University in immigration and asylum law and international refugee law. And I work as Europe Litigation Coordinator at the AIRE Center, but I'm speaking today in my capacity as the second, so as an AIRE Center lawyer. A few words about us for those of you who are not familiar with our work. So we are a charity, we're based in London, but our work is very much European, and we use the power of European law to assist marginalized individuals and those in vulnerable circumstances to assert their rights. And we represent, and we do this in three ways. So we provide free legal advice and representation before domestic courts and European courts. We provide training and capacity building to experts, and we engage in advocacy and standard setting, but that's much less the focus of our work. Our primary focus is litigation, which is my perspective for today's presentation. So in terms of the areas of law that we work in asylum and human trafficking, and I've marked them in red because these are the areas that I specialize in. But there's lots of other wonderful lawyers that specialize in other areas, such as cross-border criminal justice and family law, gender-based and domestic violence, EU free movement law, rights of the child. We have a wonderful Balkans rule of law program, and homelessness. But within asylum, that is the focus of the clinic, as I understand it. We deal with separate categories of asylum seekers, and among them we have vulnerable asylum seekers, such as children, pregnant women, the elderly, victims of torture, search and rescue, which is my particular area of interest and expertise, fundamental rights at the borders, and statelessness, which is a project that we've built and undertaken in the last couple of years. So when I first was asked to do this webinar, I had to take a step back and look at the term legal mobilization, because it's a term that we don't really use in civil society. So I was like, what does this really mean? So I went through the literature on this, and I came up with two definitions, as you can see on the right-hand column of my screen. The narrow one in which the term is defined as high-profile litigation efforts for social change, or arguably against social change, and the wider definition that would involve any type of process by which individuals or collective actors invoke legal norms, discourse, or symbols to influence policy, cultural behavior. And frankly, the work that we do at the AIRE Center within the framework of our litigation doesn't really fall under either of the definitions. My problem with those definitions, and as I can see, there's quite a lot of contest on them, even in academia, is that the first one includes the word high profile. And high profile, it has to be defined as what? Like very high court cases or cases that involve high profile individuals. And the strategic litigation that we do at the AIRE Center doesn't really fall under this. In the biggest and most influential cases, they have almost never started as a high profile case in terms of litigation or forum in which they started. The second definition involves using legal norms. Of course, we're lawyers, we are going to use legal norms, but also discourse and symbols and to influence policy, culture, and behavior. And it's difficult to, of course, measure the ripples that a case may create, but definitely we don't start with discourse or symbols for policy. We start always with a case or with a law. So this is why I struggled a little bit with the definition, and I rather went back to the term that we do use, which is strategic or impact litigation. And at the AIRE Center, of course, being lawyers and micro-analyzing all the words, we have even a problem with the term strategic, because as our founder would explain, and I should probably as a Greek know better, it comes from the word stratos, which means army. So it has a military connotation under it, strategic litigation. It's as if you're going to war with litigation, whereas impact litigation describes better what we do and can be summarized as a method that can bring about significant changes in the law practice or public awareness by taking carefully selected cases to court. And this is why I prefer this definition, because it doesn't talk about the forum, it doesn't talk about the policy. It focuses on the cases and how you select a case in order to bring about the desired impact that you have identified in your strategy. And again, strategy is unavoidable, but the military reference is there again, no? So you can't really escape it. So in practice, I went through other organizations that we work with, and none of us use the term the legal mobilization that we have given here, and I don't know why that is, but we all talk about strategic or impact litigation. And how do we do impact litigation? We usually combine it with with other internal documents that are, for instance, the litigation priorities, which identify within an organizational limit what are the areas and what areas within these areas we aim to target and bring about change. Then we have something called litigation trackers, which litigation trackers is basically a big database of cases that come to us or that we seek for proactively. And we collect the cases, and then we look for trends or try to identify suitable opportunities or developments. And then, of course, we have the case assessment or case filtering sheets that we use to screen cases in order to find the best one that is likely to bring the desired outcome. And all of this is in the framework of an organizational theory of change. So how does the AIRE Center aim to change? I don't want to say change the world, but how can we change what we perceive as wrongdoings or problems that vulnerable individuals or violations of rights that individuals face, and the organizational plan about how we can achieve it in the foreseeable future. Some of the people would view strategic litigation as a rather elitist sport, or one that could even cause exclusion, because obviously if you have 10,000 cases coming through your advice line, and you only do strategic litigation, you are bound to exclude some, and these people may still need you. So how do you do strategic litigation without sacrificing the very purpose of your organization, which is to assist vulnerable individuals vindicate their rights? And the answer is you build partnerships, and strategic litigation comes as a result of your general work and not as the main purpose of your work. This means that you will litigate some cases that will have impact potentially only for one individual, and that's okay, because that's your job. And you also will be within that framework, having seen 10,000 of these cases, to identify the one that will make a big difference and litigate for many. And this is how you deal with this potential injustice or exclusion. The other way to deal with it is also to engage in partnerships and build relations with other organizations that can help you build towards the exact same aim. So this is how to do strategic or impact litigation without sacrificing the very mission that your organization was created for. And of course, in order to do impact litigation, before you have a look at each case, you have to first identify what the problem is, when it arose, who is responsible, what authority they were acting under, can it be resolved on a domestic level? Because not everything has to be escalated to international and domestic courts. And in fact, sometimes the best solutions on impact litigation are given on a domestic level. You don't even have to go to Strasbourg. Can it be, is the problem a positive decision that a public made, or is it an omission? Is the problem a failure by a public body to do something? Is the root of the problem a public body policy? And is the practice systematic? And all these are factors that influence your judgment towards making a case strategic or not really. The most important considerations that the AIRE Center insists on implementing are these 3 bullet points that I have distilled for you on the screen. The first one is, you do not find strategic cases, they find you. That means that if you're already in the area, operating and committing to the goal, having a solid reputation in human rights, the strategic cases sooner or later will come to you because of your reputation, because of your ability to do your job correctly, and because inevitably you will have seen so many of them that you will be able to see which one of them will go to the next level. And of course, if you have been in the area for a long time, then you will have the networks that will feed you the cases to progress accordingly. The second point, so to finish the first point, we're not one of the organizations that will go on a hunt, for instance, on the Greek islands and say, okay, we're looking for an applicant who has the profile of a victim of torture, who's also an asylum seeker, so that we can litigate and change this problem. We believe that domestic lawyers know the situation on the spot better. And when they need their assistance, they will come to us and they say, we're litigating this, how can you help? And this has worked actually really effectively for us in the past. The second point is that winning is not everything, and sometimes is not even anything. And it is possible to win a case, but lose the strategy because, for instance, the court has decided to award full damages for a particular applicant, but has refused to give you a big principle that you can take and apply to all the cases, in which case you've probably lost the strategic litigation. And it is possible to lose or settle the case and draw attention to the issue or otherwise catalyze change. And the biggest example for this is MSS. MSS versus Belgium and Greece, that I'm sure in the field of asylum you all know, is a result of a string of cases that were litigated strategically and have been lost. 2 cases against the UK, 1 case against Germany, they were all lost. And in all of these cases, the court did not say that returns to Greece were dangerous, but it took losing these cases for the court to become aware that the situation in Greece was so dire that when MSS came about, it was ready to see that the situation in Greece is as grave so as not to return anyone because for fear of Article 3 violations. So again, the focus is not on winning, the focus is on operating with a plan. The third most important bullet point for those engaging in impact litigation is to define in what capacity one is better suited to help. And a lot of lawyers or a lot of academics are very, very obsessed about engaging in litigation. They want to be representing the applicant, but their expertise may be better suited or indeed help the case more from a different capacity. So what we do at the AIRE Center is we try to step out and see how can we help the case, the applicant better. Is our expertise enough to, for instance, to be the representative, to support the domestic lawyer behind the scenes? Does it have to be a third-party intervention? Can it be through advocacy? Can it be through mobilization of networks? So it doesn't have to be representation to be all and end all. You can explore different ways in which you are suited to help. Now, about how we operate at the AIRE Center, I've given you here a little flow chart that describes the lifeline of a case, and the case would usually reach us through the avenues that I'm describing here on the slide. So either through our networks or through the advice line where people can phone in and ask for our help all over from Europe, from personal contacts and from cooperation with legal practitioners or academics. They would often phone us up and they say, yeah, here I have this case or I have this individual, they want to take this case. Can you do anything about it? And then once the case gets to us, then we filter the case against the litigation priorities. And then after it passes that filter, then we do the case assessment form, in which case assessment form we look at pros and cons of the case. We also look at conflicts. And then we make a decision on the best way of litigation, in what capacity and who from within our staff is able to help. We also look for partners. Who else can we call on for support? Do we need support from an academic? And this has happened in many cases. Sometimes we need particular expertise from academics who have written, for instance, profusely in a particular area of law. So this is all a consideration for stage 2. And then stage 3, the case execution, is the litigation part. And this litigation doesn't finish with us putting the final pleadings before the final forum. Litigation finishes when you've considered what follow-up requirements you're going to need. And these follow-up requirements, and this is my next priority as Europe Litigation Coordinator for the AIRE Center, is to build up the execution of cases. Because you have only finished your work if you have got a judgment and you have seen how the member state is executing that judgment, especially on the Council of Europe level. Because the Committee of Ministers has a whole system through HUDOC exec about executing judgments, and almost none of the lawyers are following it up or have capacity to follow it up because it's a lot of work. So making sure that submissions are put in on the execution stage, make sure that advocacy efforts are made within the relevant networks, so making sure that the judgment goes on AIDA, for instance, the Asylum Information Database, and the other relevant database of AIRE, whose name eludes me at the moment, but it will come in a second. IDAL, sorry, European Database on Asylum Law. And AIRE and all the other relevant forums, so that the judgment is spread as far and wide as possible. And of course, then you consider what needs you have as a result of this action. Do you need training? Do you need to train people, or do you need to change your existing training sessions to include what you have learned from this judgment? And I'm going to give examples of these very, very soon. So the areas that we have exercised or we have practiced litigation, strategic impact litigation within asylum and migration include the following. So vulnerable asylum seekers, children, pregnant women, for instance. We have been a third-party intervener in some of the cases for pregnant women in Samos, in the reception hotspots, when they were not given access to emergency care for their pregnancies during the COVID restrictions, persons with disabilities, elderly, and victims of torture. But also another impact litigation issue that we're looking at the moment is not vulnerable asylum seekers. I call it the vulnerability of not being vulnerable, because of course, there's so many organizations that are currently seeking for vulnerable applicants because their cases go so well, that if you are not vulnerable or do not have an apparent vulnerability, but just the standard vulnerability of an asylum seeker, you have very low chances of getting somebody to notice you. So we are looking, this is part of the screening process that we're undergoing at the moment. Of course, we're looking at non-refoulement and Article 4, Protocol 4. That is a very hot topic everywhere in Europe. Of course, very high in our list of priorities in search and rescue. We were a third-party intervener in the SS versus Italy case, and did support with the crew of the Juventa. So we are trying to be very active on that front, and with search and rescue recommencing in Italy, we foresee there's a lot of prospect in that area as well. Family unity, and then another area that we're currently operating is in cooperation with the European Network on Statelessness and Asylum. This is a very interesting overlap there in terms of the protection that people get, especially if statelessness coexists with the migration situation, as well as human trafficking and asylum, or human trafficking and migration. And either that on the basis of another, or as two separate situations. So a lot of areas of interest and potential large impact within the migration sector. How we do this is we operate through a very specific network of partnerships. So you might be aware that we're operating through a strategic litigation task force for most of our third-party interventions and our asylum work. And that includes organizations such as the AIRE Center, the European Council on Refugees and Exiles, ECRE, the International Commission of Jurists, and the Dutch Refugee Council, the first line of acronym. We have a strategic statelessness project between ENS, the European Network of Statelessness, and the AIRE Center, under which we litigate together and we provide strategic training together. And this is something that's been going on for the past year and a half. I've recently become member of the advisory board of a new project, which is called the Frontex Litigation Roadmap. I'm not sure if I'm at liberty to disclose more information on this. I've sent a message, but I haven't received a reply. So I cannot disclose a lot about that project, but I'm happy to discuss previous litigation efforts regarding Frontex with you. Then, of course, we are part of the European Union Asylum Agency's Vulnerability Forum, which provides with important updates as well as, but not litigation opportunities, but it's all part of making sure that the standards that you get in litigation get a follow-up on a policy level within the EU. And a former member of the Frontex Consultative Forum, we left that because unfortunately there were time constraints. But also, we're also part of a project called Last Rights, which advocates for the rights of those who have died at seas. And when I say about, it's a very interesting project that talks about the rights of their families to recover the bodies and to have the right to a burial if you have died at sea. And it's a very interesting and innovative, albeit heartbreaking project. And of course, member of the Immigration Law Practitioners Association in the UK, but also friends and colleagues with a very big team of academics and other organizations such as PICUM or the Hungarian Helsinki Committee and other legal practitioners that help us litigate and inform our third-party interventions and practice. Now, that's a lot of procedural stuff about how we do our work, but I have two cases as well to talk about how this happens in a realistic scenario. In the first case I'll talk to you about is called Elias and Ahmed versus Hungary. I'm sure you all know about it because it's quite notorious. It's a Grand Chamber judgment, and the AIRE Center assisted in the representation the Hungarian Helsinki fantastic lawyers that represented the applicants. And this is the white head on the left-hand side is the head of our founder sitting before the Grand Chamber in Strasbourg. So the case was about, I'm sure you all know, two Bangladeshi men that went through a whole lot of hurdles and through Greece, only to be pushed back in Hungary and be detained under horrible conditions. And I'm not going to bore you a lot with the judgment, but you know that it was a very negative judgment in the end. But what you probably don't know about Elias and Ahmed was that while we were assessing the case and preparing the case, it came to our attention that the men, in order to reach Hungary, they had passed through Greece. So when we talked to them again and we said, what is happening? Why, how come, what were you doing in Greece? They said, well, we were working in this farm called the Manolada farm. And I said, wow, because at that time, the scandal about Manolada being a human exploitation farm had come into perspective. Can somebody mute their microphone because I hear some background noise? Thank you. So it was a aha moment for us because we were already at the Grand Chamber of Strasbourg and the case had gone through all the various levels of litigation domestically. We're talking all through the domestic courts. We're talking Court of Appeals. We're talking Chamber of Strasbourg. And this was a predominantly asylum case, but none of us had thought to ask the applicants whether they have been trafficked or they have been exploited on the way. And that for us was a big miss in terms of identification of a potentially human trafficking victim and thus for compensation under Article 4 of the ECHR, and potential miss of impact in terms of what we could have got the court to say or do had we known this fact. So it was also a missed opportunity for collection of time-sensitive evidence as far as this is concerned. And this case could not be argued at that level as a human trafficking or human trafficking vulnerability and asylum case. So the impact of that case, apart from the impact that it had for the applicants and the jurisprudence, was that there's need for training, not just of officials, judges, and lawyers, but also of ourselves who used to think of us as lawyers within the strict framework of asylum, about how to identify a person from different areas of vulnerability so that you can perhaps have all the elements that you need for the case together in one place before you start the impact litigation. So I wanted to use Elias and Ahmed as an example of a case that, in terms of legal reasoning of asylum, was handled perfectly, and the legal representation team did as best as it could. But as an example that impact litigation can teach you that far beyond what you get from the judgment, you get a real view of the need or the gap of need for training and advocacy in a particular setting that you wouldn't even think it existed. The other case that I want to talk to you about is a human trafficking case, or at least it's described as such. It's called Ranta versus Cyprus and Russia. In Ranta, for those of you who are not familiar with the human trafficking jurisprudence, Mrs. Ranteva is the girl that is depicted in the photo, is a Russian national who came to Cyprus on an artiste visa. And of course, when she got to Cyprus, she discovered that she wasn't going to be dancing. She was going to be working on something else. And she tried to escape her exploiters, but she was found later on. She was spotted by a colleague in a bar, and that colleague phoned up the police, and the police came to pick her up. But because her immigration situation, she had a visa, she was on an artiste visa, it was tied to her employer. The police called up her employer, and her employer picked her up. So when the employer picked her up, they called, the police called her employer, the employer picked her up, and the employer locked her up again. So the next morning, Miss Rantseva, that girl, beautiful girl that you see there, was found under her balcony dead with her handbag on her shoulder the next day. And that's her father holding her picture in court when he won the case. The AIRE Center assisted that case behind the scenes, and that's the first case that the European Court of Human Rights found a violation of Article 4 in a crime of human trafficking. And we also did a third-party intervention in the case. But what the world doesn't know or doesn't necessarily grasp about Rantsev is that it is also an immigration case, and it's the case that provides the link between immigration status and vulnerability to human trafficking, because it was only because of her uncertain immigration status that she was handed back to her traffickers. So in terms of what we learned from Rantsev as an impact litigation is that, of course, you get the big pronouncement on Article 4 and the landmark judgment and the first case of identification and the need of early identification. And of course, it's the first case that the court said that you can hold accountable not only the country that the victim is exploited in, but the country that the victim comes from. It's also the case that brings a link between vulnerability that comes from an uncertain immigration status and human trafficking and exploitation. It also gives you the important principle that you have to take to court both countries, the country that doesn't cooperate and the country that the victim faces exploitation in. And all of these wouldn't have happened if this case hasn't brought forward, or if the people that were looking at this case said, oh, this is just a human trafficking case, not an immigration case. And of course, it's very difficult to assess your impact. So how you help in impact litigation is really difficult, especially if you are a third-party intervener. But I give you here a little bit of what the judgment said in 3 paragraphs. And I've highlighted here the 2 parts. Sorry, first I've put here what we had said, and then 2 parts of the judgment that the court has literally taken stuff from our third-party intervention and put it in the judgment. So it's okay if you're not the applicant's representative, you can still have a huge impact by writing to the court a really fantastic third-party intervention with experts in the area and trying to shift the outcome towards where you want it to go. And in lieu of a conclusion, I wanted to touch upon some bullet points and leave you with these perhaps as stepping points for discussion. Legal mobilization and impact litigation perhaps are two sides of the same coin, even if we accept that legal mobilization is a little bit wider, and thus somehow it can include actions conducted, for instance, under the umbrella of activism. However, activism and legal mobilization may have a different outcome and sometimes be prejudicial to the outcome of a case. For instance, when we were litigating some of the search and rescue cases, we had asked the activists to keep very quiet on advocacy and public efforts, because the court was not to see this case as a case of activism, because it had to focus on the legal questions. And this was really, really important to get the outcome that we wanted. And of course, there's other issues that activism can be far more efficient than taking a case to court. It's just having to know what to do when. The second bit is, the second question that I want to discuss with you and see how you feel about it is it true that too many cooks spoil the broth? So is having too many individuals litigating on one issue too bad, or perhaps is it not as useful for that particular outcome? In my personal view on it is that they can spoil the broth if they don't talk to each other. For instance, when there was litigation, and this ties in with my next point about rocking the boat, when they were litigating the conditions of reception on the Greek islands, and there was one particular lawyer from a European country that went and brought a case against treatment of asylum seekers within the hotspot of Chios. And in the pleadings, when they were describing the conditions of the hotspot, he had put that the asylum applicants were malnourished because they were having too many carbs and croissant. Now, if you're getting married in 3 months, perhaps a nutrition of too many carbs is too bad for you. But if you're trying to argue before the European Court of Human Rights that that you have an Article 3 violation potentially for reception conditions, then you really would have to talk to other lawyers in the area and see what the threshold is, because the judgment of that particular case will impact all the other work that lawyers are doing in the area. So in that case, you do rock the boat. And that's not strategic litigation, that's detrimental litigation. The penultimate point that I made is sometimes strategic litigation is viewed as an elite club of NGOs that do it exclusively, and it's very difficult for the court to give permission to give third-party interventions to other organizations, and that's not true. It may be a little bit more difficult to get the standing, especially if you're an academic institution, to make third-party interventions. And we know from practice that the court is particularly skeptical in accepting such interventions, because it has had in the past some American universities who want to help students cut their teeth by making third-party interventions before the European Court of Human Rights. And this is a serious forum. People's lives are at stake. However, it does help a lot as a practitioner to have a good academic background or a good network of academics that you can reach out and give credit where credit is due, to support and work together for third-party interventions. And I know there's an initiative currently undergoing in England, I'm not at liberty to disclose full details, of course, of academics trying to build something like an academic pool where experts can register with their expertise, so that when NGOs have a need for a particular expertise, they can reach there and find the academic and be matched with the academic that they need. So impact litigation is something in migration is very, very useful. There's lots of ways to do it, but the best way to do impact litigation is to pay full respect to the domestic lawyers who work on jurisdiction, not to work for the credit, not to work to see your name in print, not to work for the glory, to work for where the need is, and to be open and accept cooperation from all possible fields, because each different practitioner has something to offer in the case. So with that in mind, I'm going to finish my presentation, being aware that I've taken an extra 10 minutes, and I will be open to discussion and or questions after we've heard from lovely Virginia. So thank you very much for your attention.
Thank you so much, Markella. This was really wonderful, and there's so many insights in there for us. I think it's very, very rich. And I honestly didn't think that legal mobilization would be something that you would pick up on to sort of, and I think it's very, very interesting. And maybe we can later discuss also with Virginia, because she engages a lot with literature on legal mobilization. And I feel like Virginia, you have also a kind of a different meaning of legal mobilization, but we can talk maybe about that later.
Definitely not an expert. I just read a couple of journals. So Virginia, please feel free to correct me.
It's very interesting. I think the very fact that the term is not used by the civil society actors that academics study, and they say that what they do is actually legal mobilization. I think it's an interesting point to which we can maybe come back later. Virginia, I'll give the floor to you now. Thank you.
Yes, thanks a lot. Wonderful presentation by Markella. Wow, I look forward to the discussion. There are indeed, as has been already pointed out, many connecting points or overlaps in a way, even though my perspective is indeed a bit less hands-on and more academic, in the good and the bad, of course. So the title of my presentation is Legal Mobilization via Preliminary Reference, Insights from the Case of Migrant Rights. What do I do? So this is a presentation that basically is my book project. It's still a work in progress. It's partly already published, but partly still on the way. So towards the end of this presentation, I will just show you where I stand at the moment. So, but the initial puzzle I started on when investigating this topic is the fact that, as you can see from these slides, we have experienced before the Court of Justice of the European Union a growing trend of migration cases reaching the Court of Justice via preliminary reference. So that means, on the other hand, that the European Union Court, so the Court of Justice of the European Union, became a very important actor and a very important court in deciding and interpreting the right of migrants in Europe. As you can see, though, from the different colors in this figure, there has been also a huge variation in terms of the topic that has been brought to the attention of the Court of Justice. And you can see the same data here, just depicted in a different way. So as you can see, there is a great variation in terms of which EU norms, which EU legislation have been brought to the attention of the Court of Justice. So the initial question that came to my mind when starting this investigation was why there are so many cases on some issues rather than in other issues, and why some countries refer so many cases while others refer no cases, as you can see from these slides again. So as you can see, Germany, the Netherlands, the UK, when it was still a member of the European Union, Italy, Belgium, and so on, these are countries that tend to refer a lot of migration cases to the Court of Justice of the European Union, while other countries such as Croatia, Estonia, Greece, Lithuania, Malta, and so on and so forth have never referred even one single migration case to the Court of Justice since the beginning of its jurisprudence, its mandate. So what is the reason behind this great variation? How can we understand this puzzle? So this is not a new question in the field of EU studies and EU litigation studies especially. We have a lot of theories that want to explain why we have so many references from some countries and not from other countries. The difference and the contributor I want to make to the field is the fact that most of the scholars that have been looking into the preliminary reference procedure have focused on the courts. As you know, the preliminary reference procedure works as a dialogue between courts. So national courts have to send the case to the Court of Justice. And that's why the scholars' attention have mainly focused on either the Court of Justice or national courts or structural factors such as the migrant population. And you might have heard of very important theories also in the field of political science, such as Karen Alter competition within courts dynamic, that try to explain this variation. Yet in reality, none of these theories really can explain the variation in the migration field. Sorry, my cat might interrupt my presentation. I hope it doesn't jump into the screen. And what I want to, what is my main argument actually for the book, and in general, is that we should consider legal mobilization practices and dynamics in order to understand this great variation when it comes to migration references. So a first outcome of my research is that actually the 267 procedure, so the preliminary reference procedure, is used not only as a tool for dialogue between the courts, as a tool for interpretation of EU law, but has also been used by civil society actors as a tool for contestation, to contest in the field of migration, to contest restrictive national migration policies. However, that doesn't happen easily. What I also found it is a kind of a difficult and bumpy process for civil society organizations to get and to reach the Court of Justice of the European Union. And that's why we have so much variation actually. And we do have this, what I call legal mobilization through preliminary references, only when some conditions are there. And these conditions, I will come back to them in the rest of my presentation, are basically two big conditions. So the first is the fact that civil society actors need to have the availability of what I've called mobilization resources, and they need to operate in what I've called an open EU legal opportunity structure. I will explain later on what I mean with these two things. So first of all, let me take a step back and explain you why legal mobilization? Why do I use this term that indeed, as Markella rightly said, it is not very used in practice. So practitioners, lawyers, judges are not very familiar with legal mobilization. The reason why I decided to pick this term and to use it in my research as a very important concept is because I have been using a lot the literature from the US that started with the famous case of Brown versus Board of Education. You can see a picture of from that case here in this slide. So in the US, we had this very important case in the 60s that triggered an important debate about the role of law in shaping policies, in triggering social change. The case of segregation in the United States was kind of the main case that triggered the debate, but then there are, of course, many other examples that you might have also heard recently because of recent decision of the US Supreme Court. But in any case, what was very interesting for me was the fact that thanks to these cases, in the US was developed a huge literature on the role of law in society, on the role of litigation in society, and making a parallel between what can be considered social movement activism and efforts to create social change and the role of law and litigation. So first of all, legal mobilization, it is an empirical phenomenon. There are many, many definitions in the scholarship out there. I use it to mean the use of litigation by collective actors, which mean civil society actors, group of activists, even lawyers associations or judges associations. Collective actors is a very broad term, to achieve a political goal that transcends the interest of the party. So how can you distinguish a common and average litigation case from a legal mobilization case? You need to see two things. First of all, the presence of a civil society actor, of a collective actors, and the fact that the main goal is not to serve the interest of the party in the case, but to achieve a political goal or social goal. Legal mobilization is also interesting because it implies a change in perspective. As I said, the preliminary reference procedure was mainly studied with a court-centric approach. What the legal mobilization approach implies is that you have to switch the perspective of the inquiry. So instead of just reading the case notes, instead of just looking at the court, you have to broaden up your perspective and look at what happens in society. Look at the political context of who are the parties, what is the relationship between the parties and the lawyers and these collective actors, and take into your picture a much more complex view of litigation. Two very important authors that you can see quoted here in the slide are Galanter and Siemens. They invited to see courts as mainly reactive institution. So courts, judges, they cannot decide on which cases they're gonna rule. The cases arrive on their desk, but the reason why a particular case arrives on their desk and not another, to understand why this case arrived, we really need to look into what happens in the broader society. So that's why it's this broader perspective is also called user perspective by Michael McCann, another very important scholar in the field. Okay, so going back now to the Court of Justice and coming back to what is a more legal approach to the study of the court. So first of all, one can ask, okay, why the Court of Justice is such an hostile court to civil society? This court has been described as hostile to collective action by Harlow and Rowling in 2013. The reason why the Court of Justice is considered hostile compared to other courts like the European Court of Human Rights is that it's quite difficult to reach. You don't have a direct action that brings you directly to the Court of Justice. You need to find your way through a very tortuous procedure. When it comes to migration, basically direct actions are very difficult to trigger and to use. And maybe we come back to this when talking about Frontex. We have some clear example of attempts to hold Frontex accountable before the Court of Justice that failed because of the very restrictive legal standing rules that the Court of Justice has. And also there is no civil society procedures like amicus curiae, third-party interventions. These are procedures that do not exist before the Court of Justice. So that's why it's very difficult to reach. And yet the preliminary reference procedure, there was a procedure that was conceived to create a dialogue between courts, has been increasingly used by civil society as a way to reach the Court of Justice. You already know it, I'm sure, but the way in which this procedure works is as it is an indirect procedure, because first of all, you need to start a case before a national court, and then you need to convince a national judge to refer the case to the Court of Justice, which is, of course, quite difficult. So how did I study this puzzle? How did I find an answer to my puzzle? I created an original database with all the preliminary references that have been referred to the Court of Justice in the migration field. And then I selected, on the basis of this database, 3 case studies that I looked and I studied more in depth. And I used, as I said, legal mobilization concept. So this is the figure that will explain a bit my case selection. So as you can see from this slide, we have, as I said, a great variation when it comes to the countries that make references and also the matters, the laws that has been brought to the attention of the Court of Justice. And as you can see in this slide, Italy, the UK, and the Netherlands are the 3 countries that have referred the majority of questions on 3 main legal instruments. Italy on the Return Directive, the UK on the family member of union citizens, right? So I'm always referring to migrants in the sense of third country national migrants, so not EU citizens, but in this case, they were third country national migrants who were family members of union citizens, and that's why they were under the scope of EU law. And then the Family Reunification Directive for the Netherlands. I consider the fact that there have been so many cases as an indicator of the fact that there could be a legal mobilization there. I thought that was kind of an intuition at the beginning of my research. I thought, okay, how can I find whether these cases are due to legal mobilization? There are almost 400 cases. It's impossible to look at them in depth, so I have to make a selection. And so my intuition was like, you know, if you have so many cases, maybe it's because there has been some collective effort behind these cases. And I was right, luckily enough, because actually I have to say now that there has been many instances in the case study that then I got to know where you have just one case, which is a legal mobilization case. So actually this is not, that doesn't work always as a correlation like that. So what I found out in my investigation, of course, I cannot really bring you through all these 3 case studies. As I said, this is a book project, so it's quite big, but I will just tell you that actually behind each of these cases, there was in fact a contestation through preliminary references. So civil society actors were using EU law to contest a national legislation, which was very restrictive or even in violation of migrant rights. When it came to Italy, it was about migrants undocumented, so under an irregular position that risk to be deported. In the UK, it was about actually a family in the UK that risked to be divided because one of the members of the family didn't have the documents to stay in the UK. And in the Netherlands, again, was about family reunification, but was about a different type of legislation that imposed a civic integration test from abroad, so even before coming to the Netherlands. So the main question that I investigated by these focus case studies was, why do we have legal mobilization in these countries and not in others? So what made these countries or these cases effective, successful before the Court of Justice of the European Union, while other cases, because you know there are many violations of migrants' rights in the whole Europe. Greece is maybe one of the most famous examples for that, and they never referred any case to the Court of Justice. So why these cases were successful and others were not? So I will just show you the example of Italy because I think it's one of the clearest, but of course you can ask me question on any of the other two cases. So what happened in Italy was that in 2002, there was a new government coming into power, very right-wing and very xenophobic. They started to implement what has been called in the literature crimination norm. So norm that through criminal law penalized migrants in various ways, in different ways. One of the most heinous or harsh laws was the one that introduced the crime of irregular stay. So if a migrant becomes irregular in Italy, he would risk be held up in jail up to 4 years. Civil society organizations started to initiate cases at the national level in order to challenge this new crime, and they failed. So they brought a lot of cases before national courts and before the Italian Constitutional Court, but actually this norm has been declared constitutional for its most important part. What happens is that in 2008, the European Union adopts the Return Directive. The Return Directive is one of the legislation that has been more accused by civil society actors. So it's one of the symbols of Fortress Europe, right? You might have heard that it's not very sympathetic to migrants in general. And yet, actually, civil society actors in Italy saw into this directive an opportunity and a possibility to mobilize EU law to reach the Court of Justice and to contest, to initiate a contestation against the Italian criminal law. This mobilization was quite broad. As I said, there were many cases brought before the Court of Justice. In total, 16 judges from any level, even the Italian Supreme Court, sent a reference to the Court of Justice. They submitted 22 references in total, and they all asked the same question. It's even the text of the reference is the same. So it's striking to see that there was really, there were not clearly all the same lawyers or anything like that, but there was a coordination between them. They were all drawing from the same sources. And the question that was brought before the Court of Justice of the European was, is Italian law in line with EU law and the Return Directive? The Court of Justice with Eldridi and Sagar gave some leeway to these claims. It didn't actually completely validate their argument. It did in part, but nonetheless, that was enough to trigger a reform in the Italian legal system. So this is just an example of how this legal mobilization can work. And I will use this case now to exemplify what are the conditions that I could identify thanks to this. So why did we have legal mobilization in these cases in particular? So first of all, in these cases, I could find that collective actors, civil society, were relying on specific resources and allies. And it's very interesting how there is an overlap already here with the presentation from Markella and what I'm going to say here, because one of the main resources that these migrants and collective actors need is the fact of having what has been called in the literature a support structure, or what I've called an alliance between migrants and collective actors, actually. So in these cases, there was what I've called an altruistic mobilization, so group of people, citizens of Italy, of the Netherlands, of the UK, mobilizing on behalf of migrants. So that's why I've called it altruistic, is because they mobilized on behalf of another group. And then the second very important resource that I could identify was Euro expertise. So actually these people mobilizing the law and bringing cases before national courts and before the Court of Justice, they were relying on a high level of expertise, of EU law expertise, thanks of the fact that they were themselves, so the lawyers were experts, or they were acting together with academics, Euro lawyers, EU legal experts, and so on and so forth, that gave them the necessary resources. So in Italy, to come back to that example, the mobilization started with an academic article where two academic professors, EU law professor, a criminal law and a constitutional law professor, sorry, they launched the idea of this mobilization, and then they had a lot of attention, and again a lot of attention, both from lawyers and from judges, and there the mobilization started. The second most important condition to have legal mobilization is the fact that in these three cases, the legal opportunity structure was open. So what is the legal opportunity? This is again a concept that I borrowed from the legal mobilization literature, and it refers not to the actors, but to the environment where they act. So they are factors that are external to the movement. There have been, as always, many different definitions of legal opportunity structure. The one that I found more fitting to this case is the fact that we have the legal opportunity structure is composed of three main factors: the available legal stock, so the law that is available in that moment, that is valid in this moment, access to court, and judicial receptivity. In the context of the preliminary reference procedure, the legal opportunity structure takes an very particular form, as I will explain. First of all, the collective actors need to perceive that EU law offers a comparative advantage and litigation before the Court of Justice. So as Markella also said, you can defend migrant rights before national courts in a very effective way. You do not need to go before EU courts or European courts in order to find a remedy. So the reason why these people decided to use the preliminary reference procedure to push for a reference was that because they perceived that EU law was more protective for migrant rights and offered some extra benefit to migrants. So that's why they decided to go at the EU level. In the case of Italy that I told you about, you might remember that I said that first, these actors went before the Italian Constitutional Court, and after they failed before the Italian Constitutional Court, then they decided to bring the case to the EU level. So that type of dynamics happen very often. So first, collective actors, lawyers, they try at the national level. If they fail, then they go at the EU level. The second part of this condition that I was talking about, so legal opportunity structure, the second factor that makes it open is the fact that collective actors and lawyers need to encounter a judge, a national judge, which is willing and able to refer a question. As I said, the preliminary reference procedure was conceived as a tool to enable dialogue between courts. That means that only the national judge can decide whether to send a question or not to the EU court. That's why it's vital for collective actors to find a judge at the national level, a tribunal or a court, which is able and willing to refer. This is like the most important obstacle that collective actors face all the time when trying to reach the Court of Justice. But actually, one has also to acknowledge that they are not powerless in front of national courts. So as also Markella said, many of these collective actors are engaging into training judges, they are engaging into conversations with judges. Academic articles can indeed reach judges and convince them to make references. So there are many ways in which the civil society can prepare a good terrain for their preliminary reference to happen. Okay, so now I will just introduce you the last chapter of my book, which is still in the making, which is, now that I've seen these factors that explain why we have successful cases of legal mobilization before the Court of Justice, why do we have cases where there is no references? So how can we explain, or do these factors help us understand why we have so many countries in the European Union that have never referred even one case before the Court of Justice on migrant rights. So what about cases where there are no preliminary references at all? And can legal mobilization theories help us understand the absence of references? So I will just come back here to the initial slide that I show you. As I said, as you can see here, Croatia, Estonia, Greece, Lithuania, Malta, Romania, Slovakia never referred any case, but you can also see that other countries have referred very, very few cases. Of course, one of the most puzzling cases is Greece, because it reserved a lot of migrants, but also Malta, of course, is one of the countries that have seen most migrants coming to its coast. So it's definitely a puzzle. I really look forward to unpack. How to use what I learned from these positive cases to understand these negative cases. So first of all, I'm gonna try to understand whether the lack of references can be understood with the lack of national judges who are willing and able to refer. So as I said, the structure of opportunity, maybe in these countries, we have a closed structure of opportunity. So it's just impossible to obtain a reference. Or another hypothesis that I have is that we have a lack of Euro expertise. So there are not enough experts in EU law. There is not enough support. Not enough support also in the sense of lack of collective actors operating on their territories. Or the last possibility is that, of course, there is no comparative advantage of EU law. So the situation on the ground is already perfect, and migrants find remedies under national law. So they do not really need to go to the EU court. So I will leave here with these questions, because as I said, this is still an ongoing investigation, and I'm very much looking forward to any idea you can have to help me out, of course. And so we'll just wrap up a bit with some conclusion. So I would argue that legal mobilization processes help us understand variation in preliminary reference rates. So why some cases reach the Court of Justice and others do not. That doesn't mean the structural factors, so the courts do not play a role. As I said, the national judge is always a very big obstacle or ally in legal mobilization before the Court of Justice, yet collective actors can do a lot in order to make judges more willing to refer questions to the Court of Justice. Then there is a bit of a critical note in the sense that in the literature has been argued that the preliminary reference procedure is a great tool to empower disempowered subjects such as migrants. Is a great tool to give them the possibility to participate in lawmaking. Actually, my research doesn't really shed a lot of light in that sense. So what I saw is that migrants do not find easy to mobilize EU law by themselves. There is always a need of a support structure. And in most of the cases, even if not all the cases, this support structure is not made up of migrants' organization themselves. So yeah, but more of organization created to support migrants. So altruistic organization. So migrants need allies and Euro expertise in order to be able to participate in this procedure. I will conclude here, and thanks a lot for your attention. Sorry also for being a bit long. Thanks a lot.
That was really, really great. Thank you so much, Virginia. I think we also learned really a lot from your presentation, and I was also happy to see some overlaps with Markella's presentation. I think that actually in the end, I'm not sure what's your opinion, but I think that actually you use different terms, but for the same thing. I think the way in which Virginia uses legal mobilization is actually the way in which Markella uses the term impact litigation. I'm not sure, maybe that's not the case, I don't know, but I was, I mean, even though I have this feeling, I'm still wondering what's the relationship between each term that you use and activism, because I feel that there might be some differences. Markella, you were saying at some point that legal mobilization is activism, but impact litigation would be something more like, like actually to prove, to sort of use a certain expertise, and actually before the courts you have to and that's totally understandable, because the courts, they also have a certain self-image, and you need to kind of satisfy that self-image of them as just being, as being there to apply the law. So just as technical experts, right? So there is a certain self-image of the course that civil society actors need to sort of fit in when they participate in litigation. But if we sort of distance ourselves from the self-image of the court, my question would be like more generally as, regardless of that self-image, do you see your work as being actually also activist? And what, I mean, yeah, more or less sort of this idea, what is the relationship between the different terms that you use, be it impact litigation or legal mobilization and activism, generally speaking? Do you see it as being actually something that is part of broader activist strategies? I mean, strategies, not.
That's a really great question. That's a really great question. It depends on who you ask, I guess. There's a certain perception that activists are supposed to look a particular way. There's a certain perception that activists are supposed to behave a certain way. I certainly think that if you are trying and doing something to make a positive change in society, you are an activist, you're a human rights activist. But there's different ways to do about it. There's activists, for instance, that work for an environmental organization and go and tie themselves on a boat. Whether as a lawyer, I would be taken as seriously by the court if I was to tie myself on a boat. I probably don't think so. Whether as a personality I'm suited to do that, again, I don't think I'm the right person for this. I think there's value in all contributions. And as I said, there are situations that activism turns out to be more efficient than taking a court case in certain scenarios, especially in the scenarios that you need to apply pressure to get a political decision. But whether they are distinct in situations, I think it depends. Your answer depends on who you're asking. And of course, it also depends to a certain extent, what means do you use to achieve your aim? And of course, there are intermediate situations. There are lawyer activists. And their activism is defined by the kind of work that they do. And certainly, there are people who are not lawyers and they are activists, but they're fighting the good fight in the camps of Moria, in search and rescue. And I engage with I train activisms on the law of the sea and how to avoid their boat being detained. It's just different viewpoints to this. But my personal view is that if you're doing something, you're active. So you are an activist.
All right. Thank you, Markella. What do you want to add something, Virginia? Maybe you're...
Yeah. So I've been struggling a lot with the definition. It's very important to find a good definition, I think. So that one of the reasons why I decided to, as I said, legal mobilization just creates a very good link with the literature that I found extremely useful, which has been developed in the US for like 40-50 years. So that was finally the final decision, the final reason why I decided to use it, but also not only because it's a very elastic term. So as you said, you came up with 2 definitions of legal mobilization, but there are so many other definitions, and eventually it really serves to capture a very broad phenomenon. You can do that, as you said. So activism is not very... There are some legal mobilization scholars that would consider activism as a form of legal mobilization, in the form of mobilizing rights verbally in discourses and so on and so forth. So that can be definitely something that fits into the definition. Yet I decided to restrict it a bit to litigation in my analysis. So as you have seen, I decided to say that legal mobilization is the use of litigation by collective actors. And the reason is that sometimes social movements and legal mobilization, so what I can say, like political mobilization and legal mobilization follow different dynamics. What has been already highlighted in the literature is that very often legal mobilization comes to be very handy when political mobilization fails. So you have the situation where you cannot really push forward politically a certain claim, a certain right, a certain political aim. And that's why, because politically your way is too difficult, you decide to use litigation instead. So this is very common when it comes to minority rights, because minority rights are very marginalized by majority in a lot of cases, and that's why you use the court, you use constitutional courts, you use the human rights convention, and so on and so forth. So I think that still makes sense to distinguish the two analytically, but definitely we are in front of very broad concept and definition, and I guess it depends a bit on the use that you want to do. When it comes to be strategic before the court, I totally agree with you, Veronica. Maybe it's not smart to call ourselves activists or something like that before the court. Legal expertise is much more appealing, and then also that can be also a consideration that should be taken into account.
Thank you so much, Virginia. Oops, I'm sorry. Zoom is sorry. I had an error message. Sorry, it happens. I was thinking about while you were speaking, Markella. I was really I couldn't agree with you more, and I really like the way you frame it, like this. So winning is not everything. Winning, you might win a case, but you might lose a strategy. I really liked this this distinction. How and I'm curious a bit to know more, about the way in which sort of you distinguish the way in which you define the strategy itself, I mean, you did say something about how you do it. You had a sort of set of very concrete questions. Like this is how we think about it, right? We look at litigation priorities. We look at litigation trackers, and I think that this is part of sort of your ways of thinking about strategies, litigation strategies overall. And I was thinking also while listening to Virginia about this case, L3D case that reached the Court of Justice of the EU. And when I think about this case, I'm like, I mean, it is an important victory, right? So I'm trying to link this case with the strategies and how we think about strategies overall. It is an important victory. In the same time, I mean, I cannot help but think. I mean, it in the same time, it has very important limits, right? In the sense that it's about mobilizing what Virginia, I mean, the Return Directive, and Virginia said that it has become the symbol of Fortress Europe, right? It's about mobilizing this tool in order to criticize policies of immigration, but in the same time, the Court of Justice, for instance, in this case, it's not like it decided, well, any policies that criminalize illegally staying migrants are not in line with European Union law. This was not really the case. It was just a decision limited to imprisonment, and within a certain kind of reasoning, which is to say, well, the use of imprisonment as a criminal sanction actually frustrates the broader objective of realizing an effective return policy, right? So the idea is to say, okay, imprisonment actually delays returns, but the overall objective is to return. So it's a kind of like a double-edged sword, right? The Return Directive, because it's the way in which it has been mobilized in the L3D case. So it does achieve a certain change, which is an important one, undeniably. But in the same time, it carries forward the very possibility of criminalizing, of having certain policies that create criminal sanctions for illegally staying migrants. It's just that there are certain limits to the way in which states would do it. So my question would be, and probably for both of you, but first for Markella, I was just thinking if you, in the way in which you think about well, the pros and cons of the broader strategy that you would have when you receive the case, do you also sort of take into account this more, let's say, more implicit assumptions that are being carried forward every time the action is being brought and even won, right? So in this case, well, the distinction between returnable and non-returnable migrants will be legal and or irregular and legal migrants, or the very possibility of actually, you know, having policies that criminalize migrants. This very possibility is sort of carried forward, but it's limited, and it is an important win, I would say, but it's in the same time reproduces certain logics of returning efficiently illegally staying migrants. So yeah, I'm not sure if my question is clear. It's more like to know if you take into account the more implicit assumptions or distinctions that the law has structurally that sort of make the system very vulnerable to also oppressive dynamics.
Yeah, I mean, I get the general idea of your question. I think that you have to take everything into account. And of course, there's a more elaborate strategy to strategic litigation. We do a training on strategic litigation. It's a whole thought process, but two of the steps that I didn't have the time to describe today is first, you have to be able to phrase the change that you want in very simple terms, right? So in MSS, this would be, we want returns to Greece to be stopped until the situation improves radically. So you have to be very, very clear as to the goal in that particular sub-area. Secondly, and after you've identified the goal, is to absolutely take into account everything that has been said on this issue before. And then the third thing that comes as a part of an assessment is to see what the potential impact of a good judgment would be, but more importantly, what the potential of a bad judgment would be. So when we did Elias and Ahmed, is okay, if we win, this is a very big thing regarding returns from Hungary to Serbia, regarding detention in the Roske transit zone. But if we lose, what does that mean for all the other cases that are coming? And what does it mean for all the assumptions, as you say, Veronica, that will come from this? And indeed, even if you do have, this assessment before, when the judgment comes and you see how many little things that come out of this are out there, you kind of lose your mind with the amount of work you have to do every time before you bring a case. It's crazy. Sure. But that having said, all that work is not without benefit, because sometimes it's not just the bad things that will come through the implicit assumptions, because sometimes the court, especially the Strasbourg court, has some really, really good nuggets in there that give you the food for future litigation. For instance, in Chowdhury versus Greece, which was the bloody strawberry Manolada case about the workers that got shot while they were being exploited in Greece. The court said in paragraph 287 that you wouldn't know if you hadn't read the judgment a million times, that the state has to eliminate anything that might add to the vulnerability of the potential victim. And that could be interpreted perhaps as in the state has to regularize those working under uncertain conditions. So there, the court itself gives you the next bit of, little cheese to go for the next step, but you have to read them very, very carefully. Right. So Yes, you have to consider everything is the short answer to your question. The long answer to your question is that you have a very difficult task ahead of you. And thank God that we cooperate with so many fantastic practitioners that sometimes this task becomes a lot easier.
Thank you so much, Markella. Virginia, I was wondering if because I imagine that you interviewed certain civil society actors that participated also in the action that you were talking about that started in Italy. And I was just curious, in continuation of with my question, I was just curious if the actors that you interviewed, they were expressing some maybe uneasiness with the fact that they had to argue, they had to push for the argument that, well, we can't have illegal migrants in prison just because they are illegal, because actually we need to return them more effectively. Right? that was ultimately the argument. Did you find some actors that were expressing some uneasiness with the fact that they had to argue this, or some doubts, or?
Yeah, no, thanks. Excellent question. Yeah, it really is it's a pretty disturbing case because the decision is pretty disturbing in the sense that indeed the court said, no, we cannot have them in detention. We have to return them immediately, which is crazy if you think about the idea behind. But well, the fact is that this was not the idea of the practitioners, right? Mm-hmm. So what they found in the directive was some hook for a better treatment of migrants, was some hook to say, the directive say that you can hold migrants in detention, administrative detention, for a limited period of time. Here we are keeping migrants in jail for 4 years. What's it? So it was a very different approach. And then after all these human rights concerns, there was also a claim of saying, and by the way, this is also detrimental for the objective of the directive, which is returning as soon as possible the migrants. But it was kind of a subordinate argument. Also, if you read the decision, if you read the questions, the preliminary question, and now I realize thinking about that, is not available on the case of the Court of Justice yet, because at that time they were not available. But the preliminary questions of the judges, they were first insisting on a human rights point, which was discharged by the Court of Justice. The Court of Justice didn't really follow that point, but picked up on the second type of concern, which still, it is of course not, it was, of course, not the preoccupation of migrant lawyers to say we should return these migrants as soon as possible, but still they've reached their goal of abolishing the detention for these migrants. So it was a very effective strategy in that sense. It was limited in the sense that still we do have a crime for irregular stay in Italy. So the court didn't say that criminalization is wrong, that crimmigration is a wrong policy, or this is contrary to EU law. The court just said long detention is wrong. So that's why we didn't really have abolitio criminis, as it's called. So the crime is still there, but it's just not punished with detention. So it's a very limited victory. But yet, if you look at the people that have been freed because of this decision, and even the number of cases that have been dropped, so the impact is undeniable. So on migrant situation is really something that you cannot even argue. And even if you talk to to criminal judges, the criminal judges in Italy, they were dealing with so many of these cases that they couldn't do their normal job, because from one day and another, all the irregular migrants in Italy were brought to their desk. Basically, they had to deal with a lot of cases, which were not criminal per se, but were about migration status. And that was also a huge justice problem in general. So I think that in that sense, it really was a kind of a successful case with structural limits. And it also shows this case very much the difference between the Court of Justice and the European Court of Human Rights, that instead, as at the center of its mandate, the human rights of people, right? The Court of Justice is a court with a different jurisdiction. It uses a different legal basis in order to decide its question, its judgments, and also the type of reasoning that you have before the Court of Justice is very different. normally it is not a human rights type of reasoning, right? It's much more functional, it's much more linked to the objective of EU law, and in that sense it can be less sympathetic to civil society claims, but yet it can be also very effective under a more practical point of view, I would say.
Thank you so much, Virginia. That's really, really interesting. I think I lost track of time. Sorry for that. I will just ask you if you could give us 5 more minutes so that we can have a bit of questions from the students. So I have Carolina who is asking a question. She's unfortunately she cannot speak up because she's in an open space with other people. Carolina is asking, the role of migrants in legal mobilization is mostly very marginal or sometimes even absent. And if we think about a stronger role of migrants in strategies of legal mobilization, so should we think about a stronger role of migrants in strategies of legal mobilization? And if we do so, aren't they also ultimately still dependent upon the altruism of civil society actors, altruism, the term that Virginia uses? Can we think about ways of making them less dependent upon the altruism of civil society actors? Great question. Thank you, Carolina.
Yeah, fantastic question. Thanks a lot. I think that also Markella actually might have something to say about the relationship between collective actors and the migrant, because she is directly involved in this. So what I can say is that with migrants, we mean a lot of things, right? So it's a huge category. I am myself a migrant in this moment because I'm in another country, I'm not in Italy. So it really depends on who we are talking about. In most of the cases that I've seen, they did have a very marginal role, or they were even absent from their proceedings. The proceeding was just brought on their behalf by the lawyers. So definitely I saw that. But I also saw that things were a bit changing in some specific context. For instance, what I saw, one of the long-standing litigation that we have in Europe, and one of the long-standing migrant groups that we have in Europe is the Turkish citizens in Europe. A huge flow of Turkish workers arrived in the 60s and the 70s in Germany and the Netherlands. And there you can see some of the first cases brought before the Court of Justice in the 80s on their rights. And actually what is happening here in the Netherlands, and it was very interesting to see, is that now you have Turkish migrants with a law degree became lawyers themselves, and they started litigating by themselves these cases. So of course it was a long process, it took 40 years, but now we see these Turkish lawyers litigating on behalf of Turkish communities, and this is beautiful to see. And of course, so it's a process. When it comes to newly arrived migrants, this is much more difficult, and I think that we would still need to have altruistic actors, and they do play a very important role for them. But I would like to hear what Markella thinks in that sense.
I think that's a good question, and sometimes it's not just the goodwill of the NGO that plays a role, it's also funding, and it's also capacity, because what you end up is, 5 overworked case workers who can only help as many people as they can. And then there's so many people that have the need. The only remark that I could usefully add here is that the Strasbourg court is much more friendlier court for self-litigants or litigants in person. And sometimes even for Rule 39 measures, especially for Rule 39 measures of people who are about to be deported, for instance, or who might face an imminent risk of irreparable harm, the Strasbourg court is more receptive to applications and granting application from litigants in person rather than by lawyers. And it appreciates, people's firsthand experience. And in that scenario, there's no question about, nationality or access to court, because any person within the territory of the Council of Europe member states can apply to the court straight away. So it doesn't, obviously it would imply a minimum of resources, but the court has been seen to grant Rule 39 measures even for handwritten Rule 39 applications as a letter from prison from people who are almost illiterate. So no lawyer. So we have seen this. But of course, in order to get there, you just need people to be given the minimum of information to know that this avenue is available to them. So you're right, there is a limitation there. But at least the information provision can be given by more people than the civil society NGOs.
Wow, very interesting. Thank you so much. Maybe we can have time for one more question. If there is a question, I don't know, Emilia.
Yes, I was just curious to know something. First of all, thank you so much for both of your presentations. It was really amazing. And I want to direct this question to Markella. It's just a curiosity. If you could tell me, for example, how much does it take for your work to be done, as in from the moment you received a case until the moment, as you said, you can say that the litigation process was indeed completed. Thank you so much. Oh, just your mic, please.
You mean from the in a case before the European Court of Human Rights?
Yes.
Oh, it can take years.
Okay.
I mean, the current case deadlines is 3 months from the violation. So, and if it's a continuous violation, then perhaps you can argue a bit more, but so you have 3 months to prepare your application, you put in the application, and then you wait for the judgment. And the judgment, we have some cases pending before the court for as long as 9 years. So in the meantime, people come and go. I've went, had a baby, came back, seasons change. And you never know when a judgment can come back. In certain issues, the court comes back super fast, and super fast I consider a year or months. Although in the last 3 years, I've yet to see a case decided in months. So it's a year minimum. And then after that starts the execution. So from start till finish, I'll say years. If you want like an average, 3 to 4 years, I'd say.
Okay, thank you so much.
No problem.
All right. Well, it's 5:05, so unfortunately, I really wish we could continue the discussion because it's really interesting, and we had so many insights from both of you, and it was really, really wonderful to have both of you in this webinar. So I want to thank you again for being with us and for offering your insights to us. It was really a pleasure to discuss with you. Thank you again. Bye.
Thank you very much.
Thank you so much,
everyone. Lovely meeting and seeing everyone. Thank you for being such a good audience.
Goodbye. Have a nice evening.
Thank you so much.
Bye.
Thank you.